The Supplemental Testimony. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 566. SCAO for State Court Administrative Order, PC for Probate Court, Form 566. You're welcome to contact my office. We'd be happy to provide it to you free of charge. As you can see from the title of this form, it is a supplemental testimony, which suggests through its name that there is a primary testimony. So again, don't confuse this document that's used in probate administration to begin the opening of an estate with the testimony to identify heirs and devisees. The supplemental testimony is to identify non-heir devisees in a testate estate, an estate in which there's a will. So testate with a will, intestate, no will. So this form is only used when opening an estate in which there are non-heir devisees. And an heir is defined under Michigan law as a particular type of person related to the person that died. So it's a non-heir and they're named in the will. They're a devisee. So again, a very particular use of this form. Now with all of the SCAO forms, they are created or given rise to their creation and formation by various statutes and court rules. As you can see from the floating yellow arrow at the bottom right corner, MCL 700.2702 and MCL 700.2707 through 2710, as well as the court rule MCR 5.302, are the primary statutes and court rules that create this document. And those court rules speak to testate estates in which there are individuals who are non-heirs but are being given a gift within or identified within the will. So again, when there's a will and there's an heir who's a non-heir who's a devisee, this form is used. It's used with the application or petition for probate and the testimony. This is the supplemental testimony. I know I'm repeating it, but again, just to be assured that people don't confuse the two documents. When you use the supplemental, you also must have the testimony, which is covered in another YouTube video that I've put together. Let's work our way through the form. Top left corner is the county in which the probate is being opened. Top right corner is the file number. And usually when you're filling out this form, there is no file number at that time. So generally that information is left blank. The top section is the estate name, so the name of the person that has died. Now you can see with a lot of asterisks and in bold print, it says, use this form only if a devisee named in a will or codicil is not an heir of the testator. So again, this form is a particular use. Now a will and codicil, again, terms that you may or may not be familiar with. A will is the testamentary document. The codicil could be the change or amendment to that will. If they're a devisee in the will and they're not an heir, you use the form. If not, as I've described a few times, you just use the testimony form. And then there's a note. It says, treat all persons who died within 120 hours after the decedent as if they did not survive the decedent. So this is the 120-hour rule. Again, another rule that is defined under statute. With all of these state court administrative order forms, and anytime you're going through probate or trust-related issues, it's really important to be working with a skilled, competent probate lawyer to understand the various statutes, court rules, to understand what documents to file, how to fill out the forms, what many of these words mean. I mean, you can see just from this particular document, there's something called a testimony, not a normal term that most lay people understand. Non-heir, devisees, testate. These are terms that are defined under Michigan's statute relating to probate administration, not common language that people are generally familiar with. So again, work with a skilled, competent probate practitioner to understand how to fill out this form. Number 16, and why does this form start at 16? It's because the testimony ends at number 15. So again, this is the supplement to that original testimony. The names of all devisees named in the will and codicils who are not heirs of the decedent. So again, these are the names of those individuals. You would identify them there. So that is for 16. Number 17 and 18 speak of if those people that were named in 16 have died before the decedent. So we always look at the snapshot as of the date of the death of the decedent. So if somebody named in the will is listed, but they died before the decedent, you would identify them in this particular place, number 17. You check that little box, and you'd identify if their name and their relationship to the decedent. And again, the relationship could simply mean Devisee, that they're identified and named in the will. 18 talks about people who died within 120 hours after the decedent. So again, this is that 120-hour rule I was referring to. You check that box and then identify the name of the person, the relationship, the date of death, and the time of death. Again, a very particular aspect of somebody dying within that 120 hours, 5 days from the decedent. This happens often in common accidents or coincidence based on death. Again, 17 and 18, now we're going to move on to 19. And it speaks about the following are descendants of the predeceased Devisee. So predeceased means they died before the person that is the subject of this probate and who survived the decedent. So now we're identifying heirs or descendants of the person that was named in the will who are identified above. Number 20 speaks of class gifts. Think of class gifts where it says, I give to, all of my third cousins, right? They're identifying a class of people. I give to my hockey team, the members of my hockey team would be a class gift. So you'd identify those people in this particular section, a class gift, because sometimes the testamentary document is not particularly careful about naming the individual names, but gives a gift to a larger class. Number 21 on the back side of the form talks about anybody that's under a legal disability, so that anyone that is named in the will as a Devisee, who's a non-heir, who's under a legal disability, you identify their name, the legal disability, maybe they're a minor, maybe they're under guardianship, and so on. 22 speaks about deceased Devisees who happen to live over the 120 hours, the 5 days, and their name. So these are what we call post-deceased Devisees, people who died over 120 hours after the decedent. So they survived more than those 5 days or 120 hours, but then they died subsequently thereafter. And you'd identify the name and their name as well as their representative. Now, if there's a guardian ad litem for any of the Devisees who are unborn, unknown, or unascertainable. So again, there are particular rules relating to the appointment of a guardian ad litem. We call it a GAL. Those rules are defined under statute and court rule that identify when a guardian ad litem needs to be appointed for people that are unborn, unknown, or unascertainable. So again, a provision under 23 to identify that particular area. Now again, with this entire document, some odd language, all sorts of very particular questions that are being asked, not an easy document to fill out. But again, you're filling out this form as an affidavit. It's a sworn statement, sworn before a notary, of which there's a notary block and the signature of the person filling it out. Also a place for the attorney. So it's really critical that when filling out this affidavit that you understand what these terms mean and how this form is used in conjunction with the testimony and the application or petition for probate that's filed with the probate court. It's really frustrating for people when they fill the forms out incorrectly. They file it with the probate court only to know that they filled it out incorrectly, and then all that time waiting is wasted because they kick the documents back to fill it out again. So do it right the first time. At the Probate Pro, we're passionate about everything probate. If you have a question about the supplemental testimony to identify non-heir Devisees or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.